Number one versus Rico McGuire. The record should reflect we've had an extensive in-chambers conference, and I guess coming out of that is a couple of things. First of all, my understanding is that now all of the buildings in Arbor 1 West have been red tagged and are, in essence, condemned. What that basically means is that all of those individuals need to not be there or in those particular units. So that became the first, or once that was at least sent to the court, that became the first issue of trying to figure out who has not been relocated. I want to hear from the tenants. I want to hear from the city of Ypsi, but I think, or the city of Ypsilanti building officials, but we've got to deal with that immediate problem.
This hearing wastes absolutely zero time pretending it's business as usual. Judge Simpson opens by making the real issue painfully clear. This is no longer just a landlord-tenant dispute about repairs, delays, or inconvenience. This has escalated into a full-blown housing emergency. The buildings are red-tagged, effectively condemned, and that changes everything. Once a property gets to that point, the conversation shifts from, "When will management fix it?" to, "Why are people still being forced to live in conditions the city says are unsafe?" And that matters, because it tells you what kind of hearing this is about to become. Simpson walked in with one kind of docket, but the second he hears that multiple buildings are condemned, the entire courtroom priority flips. He's no longer just sorting through complaints one by one. He's now trying to figure out who is still stuck in these units, who has been displaced, who's been shuffled around, and whether anybody in charge actually has a coherent plan. That's why this opening is so important. It sets the tone for the whole case. This is about emergency relocation, tenant safety, and the fallout of a housing operation that appears to be collapsing in real time. And if you're management here, this is not the kind of sentence you want to hear from the bench in the first minute. We've got to deal with that immediate problem. Because when a judge says immediate problem, the patience phase is already over.
There are then two individuals who, Miss Llewellyn and then Grove, who we sent questions to, and I disclosed it to council, basically asking, did they wish to testify before the court? The other issue becoming whether or not they had been relocated. Again, I think the second thing I just brought up is the most important thing. Ms. Grove, can you hear me?
Yes, Your Honor.
All right. You had indicated via the chat feature that you were at 3 different hotels.
Yes. So 2 weeks ago, they were going to fix our bathroom. And so they moved us into a hotel for a week. And then when we were supposed to be coming home, they give us another confirmation for another hotel because they had not started when they were supposed to, which was supposed to be on that Monday. They didn't go through that whole week. They waited until I think it was Friday, perhaps, to actually start doing the work. And then so from that Friday, Saturday to the next week, we stayed in a hotel. And then last week we finally just came back because my son has to go to school. And we weren't able to go from that part of Canton or that part of Ypsi directly to his school.
Okay.
And then they said, "Oh, and I'm missing a step before. I'm so sorry. There was a 4th hotel booked for last week for them to fix what they did wrong. But my partner did say, can you guys reschedule or something? We really can't do this right now. So there was a 4th.
Okay, thank you, ma'am.
And here's where the case starts to get really ugly, because Miss Grove's testimony doesn't sound like a relocation plan. It sounds like housing roulette. One hotel becomes another hotel, then another delay, then another booking, then another disruption, all while a family is trying to keep life functioning. And the detail that cuts through all of it is the school issue. Her child still has to get to school, routines still exist, work still exists, and yet the relocation process being described here feels like it was designed by people who only thought about where to put bodies for the night, not how families actually live. That's the distinction Judge Simpson is starting to zoom in on. Relocation isn't just, we handed you a hotel key, problem solved. Not legally, not practically, and definitely not morally. If a family has to bounce from hotel to hotel while repairs drag, school routes collapse, and there's no clarity about how long any of it lasts, then what management is offering is not stability. It's temporary chaos packaged as assistance. And this is the kind of testimony that changes a judge's temperature fast, because it gives the court something stronger than a vague complaint. It gives a timeline of disruption, 4 hotel arrangements, repeated delays, work not started when promised, a family trying to function in the middle of all of it. That's not just inconvenient. That's evidence that whatever system was supposed to protect these tenants was already failing in practice.
Is it Gamble? You have also not been relocated. Is she one of ours?
Yes.
Why don't you come up to the podium, man? 1 second before I get to you. Miss Grove, I had one other question for you.
Yes, Your Honor.
When you were talking about your kids, how many kids are you talking about that you have to try to get to school?
One that I have to get to school, and one is 3 and not there yet.
Okay, gotcha. So you have one that the issue regarding schooling.
Yes, sir.
All right. I'm sorry, Ms. Gamble. I just wanted to make sure to get that in. Okay, well, thank you. You know, it's just nice. You need to tell these people that because they weren't listening to me when I was talking. All right. You haven't been relocated. Has there been an offer to relocate you, ma'am?
Yes, Lynette offered to relocate me 2 weeks ago, and the day that she asked me, I had to think about it. Then the next day I had to work, so it just didn't cross my mind. But she asked me on a Thursday. I don't know what day I came to see Alex Henry, but the day that I see him, that's the day that she asked to relocate.
All right. All right. Let me ask you this. How many people are in your unit? Just you? Oh, and a dog. That means there's 2, right? All right.
Yeah, I promise.
So would you like to be, well, you have to be, which is the real issue.
They gave me to the 15th, which was tomorrow. So had I been relocated to a hotel that she claimed that she was going to put me in, I would have came back to the rear tag anyway. So I would have had to leave again regardless. Because I got the red tag on my building door last Wednesday.
Okay, so say that to me again. I want to make sure I'm understanding.
Okay. The day that she asked me was on a Thursday. That following week, which was last week on Wednesday, I got the red tag. When she told me that she would give me a hotel, it was going to be until April 15th, which is tomorrow.
This exchange is one of the most revealing moments in the hearing because it shows the exact kind of uncertainty that turns a bad housing situation into a full crisis. Ms. Gamble isn't just saying she was offered a hotel. She's telling the court she had no clear understanding of what happened after the hotel stay ended, and that is a massive problem. Because if your building is red-tagged and you're being told to leave, the next question is not optional. Where am I supposed to go tomorrow? Listen to what's happening here. She's trying to piece together the timeline herself in front of the judge. She's basically saying, even if I had accepted the hotel, it sounds like I would have had to come right back to a condemned unit anyway. That is a disaster of communication at best, and negligence at worst. A relocation offer that ends without a clear plan for what comes next isn't really a relocation plan. It's a countdown clock. This is exactly why Judge Simpson keeps slowing people down and making them repeat details. He's not doing it for drama, he's doing it because the record matters. If tenants are being moved out of unsafe units with confusing deadlines, unclear extensions, and no firm next step, that becomes central to whether the court believes the landlord's side has acted responsibly.
So had I been in the hotel this entire time, I would have had to come back and leave again.
Okay, so let me ask you this. If the issue wasn't resolved by the 15th, what you had to come back. So nobody told you what would happen on the 15th?
No, I just assumed that the hotel would be up and I would have to come back.
Okay. All right.
Bring me peace, not-
Pardon?
So I'm trying to bring you peace, not pain.
Gotcha. No, it's okay. Mr. Freeman.
I just didn't hear it. Got out so I could hear better.
Oh, okay. You heard the last part that she indicated that on the 15th, she believes she had to come back because there's nothing that tells her anything different than that.
I thought she said that they don't offer to relocate.
I said that, yes.
Yeah, they did, but she would have to come back on the 15th.
I'm not relocating.
She specifically said a hotel, and she wanted to know if I wanted to be in a hotel in Ypsilanti or in Harvard, because I go to school at Washington Community College, and I work at University of Michigan Hospital in Ann Arbor. She wants to know where I wanted to be at as far as a hotel.
But you don't know. Okay. All right. So where do you want to be?
I want to be in another apartment. I don't want to be in a hotel.
I know. Stay right there. So here's also part of my concern. As it stands right now, these individuals being relocated to hotels, they can't go back or aren't supposed to be going back. So, I mean, what is the longer term solution for them?
Well, I think that for all these cases that are in front of you, the long-term solution is for them to be placed in other certified units, either our the villas or some other certified unit. But they're not all available immediately. So we're putting people in hotels because they can't be in the buildings. So we're putting people in hotels till we can find them places.
Now we finally get the landlord side's broad answer, and on paper it sounds simple. People can't stay in the buildings, so we're putting them in hotels until permanent units are available. But the problem is, by the time this explanation lands, the testimony already on the record has made that answer sound a lot cleaner than the actual reality, because what the court has heard so far is not a smooth emergency housing operation. It's families getting bounced around, tenants confused about deadlines, units allegedly offered without clear long-term planning, and a general sense that relocation is happening in fragments rather than through any stable system. So when counsel says, "We're putting people in hotels till we can find them places," Judge Simpson is basically left with one giant follow-up question. Fine, but are those hotels actually functioning as safe, consistent temporary housing, or are they just a holding pattern with no guardrails? That distinction is everything. Courts understand emergencies. Buildings get condemned, repairs fail, crises happen. But once you've displaced tenants, you inherit a new responsibility. The replacement housing can't be just barely something. It has to be workable, safe, and clear enough that families know where they stand. Otherwise, all you've done is move the instability to a different address.
It's not feasible at this point to just say to everybody. Plus, remember, until the latest red tagging, we were working on getting their units back together and fixed up so that a lot of them could go back, because that's a big problem.
Okay. So,
I'll find it.
okay. No, it's okay. All right. So, Miss Fluellen, you have already moved. Is that correct? Oh, you just muted yourself.
Okay, yes, correct.
Okay. So you already have another unit.
I moved out. I'm not dealing with them at all. I moved to a whole
Say that to me
different
again.
I moved to a whole different complex. Not with them.
Got it. Okay.
Due
All
to
right.
black mold, so uncomfortable in my home with the maintenance people just entering my unit.
Okay. All right. The individuals that are in back, who are tenants in there? Okay.
Erica Reed would also like to speak to the court about relocation issues.
Ms. Reed? All right. Come on out. No, you can, no, I'll make you guys share the podium.
I have a question.
Oh, hold on, Ms. Llewellyn. Hello, what's your name?
Okay.
Okay. And so, have you been relocated?
Yes.
Where to?
572 Delaware.
Okay. All right. You said you wanted to tell me about,
Yes, Your Honor, she hasn't had no heat since day one, and her ceiling has caved in. Uh, They keep promising her a new furnace. She is the tenant that has been living in the hotel, paying out of pocket several, for over 2 weeks now.
And this is where the hearing stops being merely chaotic and starts becoming financially brutal. Because now we're not just talking about unsafe units, hotel shuffling, and broken promises. We're hearing that a tenant has allegedly been paying hotel costs out of pocket while dealing with no heat, ceiling problems, and failed repairs. That is the kind of detail that makes a courtroom go quiet, because it flips the burden in the most unfair way possible. The person living through the unsafe housing conditions is also the one absorbing the emergency expense. Think about how upside down that is. If a unit is unlivable due to serious code or maintenance failures, the tenant should not be the one funding the fallout just to stay sheltered. Yet that's exactly what this testimony suggests happened. And then it gets worse. The relocated unit apparently had its own problems too. So the court is now hearing about a chain of housing failures where the original unit is bad, the replacement is bad, and the tenant ends up paying the price anyway. This is also a pivotal moment strategically, because reimbursement is one of the few issues here that can become very concrete, very fast. Judges can argue over timelines and intent, but hotel bills, receipts, nights stayed, that's tangible, that's measurable. That's the kind of thing a court can order paid.
need that file too, please. All right. And all of that's correct, ma'am?
Yes.
So the unit that you were relocated to, the ceiling fell in?
Yes, the ceiling was out when I moved in, but they repaired it. I guess the next day. Came to the unit and it was fixed, but it was full of water. The floor was full of water. The ceiling was full of water.
Hold on. That was the new unit that you moved into?
Yes. So the same issue occurred, you know. The tub was falling out of the ceiling.
So where are you now? You're in a hotel.
Well, back and forth from my mom's house and the hotel. They said they were gonna bring a furnace Thursday. Never brought the furnace.
What's your name? I got that one. What's the last name? Is there a case pending, sir? There's not. What did you want to? Why don't you come on up? We'll just squeeze you all in there. Can you spell your name, please?
Bravey. Last name Johnig.
Okay. And what did you want to tell the court? Although I don't have a case before me regarding.
And he says, thank you. I've asked for heat. I was told several times the heat works. I finally got a heater after I was berated and degraded. I asked for heat. And I was told that the heat was fixed by the certified boiler operator. I was asked for the heat back. I said, no, I'm holding my ceiling. One of the leaks from the neighbor down to my tub. So it's a big hole. And there's another leak where on the left side where the toilet is actually sinking down. So it's just a matter of time to fall. I expressed to them that I'm disabled. I have 2 spinal fusion surgeries that I'm healing from. So when it's cold, I'm in pain. And my nerves and shit. Said, when the heat burns, I said, it doesn't. Please. Since January 2nd. And then February, 2 days ago, I got the red stick, which indicated that February the 2nd, the place was working again. So I'm back to I can't have a video.
What was your last thing?
My daughter always wants to visit, but it's too cold. It's not having it smells. It smells spoiled.
That line is devastating, and it lands harder than a long speech ever could. In a hearing full of legal procedure, relocation logistics, and housing code language, this is the kind of sentence that cuts through all of it and reminds you what these cases are really about. A tenant isn't standing there talking like a legal strategist. He's saying his daughter wants to come visit, but the place is too cold. That's not just a maintenance complaint. That's a basic human failure of housing. And notice how often these stories keep circling back to the same core themes: no heat, water intrusion, damaged ceilings, broken tubs, uncertainty, and people trying to survive in units that don't sound remotely stable. By this point, the pattern is impossible to ignore. These are not isolated one-off annoyances. The court is hearing what looks like a broader breakdown in habitability across multiple units and multiple tenants. It also matters that this gentleman apparently doesn't yet have a formal case in front of the judge. Simpson makes that distinction carefully. He can't just start issuing individualized rulings for every person who walks to the podium if the case isn't properly before him. But he also doesn't ignore what he's hearing. He lets it onto the record, and that's important, because once these conditions are voiced in open court, the landlord side loses the luxury of pretending they weren't on notice.
All right, hold on a moment. Is this gentleman intending to file an affirmative complaint?
We just sent him the Oregon tape form.
Got it. Okay. Okay. I'm not gonna cram any more people up here, maybe, I don't know. That's Mr. McGuire back there, right? And then,
Your Honor, there was one more tenant who had to leave to take her final exam, Jayla Evans. She
Okay.
says she has not yet been reported.
Jayla Evans. And Mr. Friedman, do you know anything about Miss Evans?
She was offered a hotel. April 3rd.
So Miss Llewellyn is taking care of herself. Miss Llewellyn, have you guys talked to her?
Yes, we have. I think we were going to help her with a motion for escrow.
Okay. Well, I'll deal with that at some other time, but she's in that process. And has anything affirmatively been filed? I guess I shouldn't put it that way because that means something different now. But in terms of a counter complaint or anything else in the Grove matter?
I believe they filed something on their own, Your Honor.
Did they? Okay. Mr. Friedman, was there anything else that you wanted to?
Oh,
Okay. I frankly thought it wouldn't have to be said, but when I listen to Miss Reed, when I say relocation, that's into a place that at minimum complies with the Michigan health and safety codes. I mean, you can't relocate somebody to a place they can't live. I mean, it just, yes, ma'am.
As for the relocations, that people are telling you, it's very discouraging for me to want to move into a place that they suggest, if you understand.
Yeah, no, I get you. And let me just explain to you. So for the cases that are before me, my primary objective, while having a different one when I walked in today, right? But now looking at everything, realizing that all the buildings had been rag tagged, my primary objective is we need to get the individuals out. That really is it. But then when I listen to Reed, problem is, yeah, I got to get you out, but I got to get you out in a place that just meets the minimal requirements for health and safety. I mean, you can't. I could get you all out if I was going to put you in a parking lot. I mean, but that's not what we're supposed to be doing here. So, here's what the court's going to order, and I'm just going to have to specify my orders a little bit more clearly, and that is that the tenants which are subject to this court's jurisdiction are to be relocated to units or places that meet Ypsilanti housing code and the state of Michigan housing code requirements. Because I've heard from them today, I'm going to indicate that do you have children that you're trying to deal with, or no?
Yes, I have, 2 3
Okay. Okay. So there's three of you. Is that now? You're four.
13, 14, 18.
Okay. So for you, I hear you, and I wanted to hear from you because now they are at least placed on some notice. I have to have a case before I can rule specifically on your case, and it's just you, right? That's right.
This moment is a really important reminder of how judges operate when a courtroom starts filling with people who clearly have related problems, but not all of them are technically before the court in the same posture. Simpson is sympathetic here, you can hear it, but he's also drawing a legal line. He can't just freestyle relief for every tenant on the spot simply because their stories sound credible or urgent. He needs jurisdiction over the specific matter, a proper filing, and a case record he can actually rule on. That might sound cold from the outside, but it's actually one of the reasons this hearing matters so much. Simpson is trying to do two things at once: respond to a housing emergency while also staying inside the boundaries of what a judge is allowed to order for each individual person. So when he tells this tenant essentially, "I hear you, and now they're on notice, but I still need a case in front of me," that's not a brush off. It's the court saying, "Your problem is real, but I need the legal vehicle to act on it properly." And honestly, that makes the broader situation look even worse for the property side, because even outside the named cases, additional tenants are showing up with similar stories: cold units, habitability problems, displacement issues. That suggests the court isn't just dealing with a narrow dispute between one landlord and one resident. It's staring at a cluster of failures spreading across multiple units and multiple families.
You and the dog. I'm sorry, I didn't mean to put it that way. I just that was an awful way. And I know my mom will raise me better than that. Just say just you. All right. So here's what I'm going to order. That Miss Reed is to be relocated according to the court's new order. She doesn't have to reside in that unit that they put her in. They need to find some other unit or some other place for her to reside that meets Ypsilanti and state code. Ms. Gamble, same thing. She's to relocate to a place with and looking more toward permanency of residency, but it has to comply with Michigan state code and Ypsilanti code or the jurisdiction in which the unit resides. So that probably also should be part of that. And I'm also going to order that for the individuals in the Vance matter. Did they leave already? No, it's Grove and Vance. Yes, in Vance and Grove, that they are to be relocated to a suitable residence, with keeping in mind to cause the least disruption to the family. We cannot have these relocations that are lasting at these hotels, particularly for families that are lasting a period in time without them having notification of the renewal so that they can stay there. So what I'm also going to order is that individuals that are relocated to a hotel, they are to be notified not less than 3 days prior to the expiration of the stay that they are going to be able to continue to stay at that location.
This is one of the biggest rulings in the entire hearing, because Judge Simpson is no longer just telling the landlord side to relocate people. He's now putting structure and notice requirements around those relocations. And that matters a lot. Up to this point, one of the ugliest recurring themes in the testimony has been uncertainty. Tenants not knowing whether a hotel stay is ending, families getting bounced around, people worrying they'll be dumped back at condemned units because nobody told them what happens next. Simpson clearly sees that as unacceptable. So what does he do? He builds a rule right into the order. If someone is being housed in a hotel, they must be told at least 3 days before the stay expires whether they can continue staying there. That's not some small housekeeping detail. That's the court trying to stop this revolving door chaos before it keeps wrecking people's lives. For a family with kids, work, school, transportation, and medication routines, 3 days of notice can be the difference between a difficult situation and a total collapse. And notice the logic behind the ruling. Simpson is essentially saying emergency relocation doesn't give management permission to operate on vagueness. If you are the party moving people out of condemned units, you don't get to shrug and say, "We'll see what happens on checkout day." The court wants predictability, communication, and continuity. That's the hidden force of this moment. Simpson is turning tenant panic into a formal rule, because once the record showed people being bounced around with no reliable timeline, the court had to step in and impose one.
The intent is you just can't put them in there and, like Ms. Campbell was saying, well, I'm out on the 15th and I got to come back. Or like the Groves where they're bouncing around and then they all of a sudden end up back at these condemned units because they can't be there. Sir, what I've given a general order. It really doesn't necessarily apply to you, but if once I have a case in front of me, my intent is going to be to have this gentleman relocated immediately to a suitable location. And as to Ms. Evans, who is not here, but I've heard from council representative, she is also to be relocated. Do you know how many are? Okay, but she is to be relocated in accord with the order. So those are specific relocations that need to take place. To relocate, all of these individuals are to be relocated by Friday, 5 o'clock.
Your Honor, Mr. Friedman indicated
Go ahead.
that plaintiff would reimburse Ms. Reed for her out-of-pocket hotel stay. I just want to make sure that that's also.
Mr. Friedman?
We discussed that.
Yes. So, ma'am, do you have your cost of staying at the hotel?
I can get it from, because I was staying at the hotel that I work at.
Okay.
Yes, and they gave me a discount for it. I think that's a night.
Got it. Okay. So I want a copy of your out-of-pocket expenses. I need you to submit a copy to the court. I need you also to submit a copy to, are you representing her or no?
This section may sound procedural, but it's actually where the hearing gets financially serious in a very concrete way. Judge Simpson is now focusing on reimbursement, and specifically on the out-of-pocket hotel costs that Erica Reed reportedly paid herself. That's a major development, because it moves the case from broad housing outrage into something the court can directly quantify and enforce. And the way Simpson handles it is important. He doesn't just say, "Yeah, that sounds bad." He starts building the paper trail. Get the hotel costs, get the documentation, submit it to the court, submit it to legal services, and get it in front of the relevant parties. Why? Because judges don't order reimbursement based on vibes. They order it based on a record. Receipts, bills, dates, amounts. Once those numbers exist on paper, the issue becomes much harder to dodge. This is also a quiet but brutal moment for the property side, because the court is effectively acknowledging a possibility that should never have existed in the first place. A tenant may have had to pay to house herself because the living conditions tied to the property were so unstable. If that's what happened, then the landlord's side isn't just dealing with bad optics or angry testimony, it's potentially dealing with court-ordered repayment.
Her answer is difficult for answering counter complaint, but I have to do.
Okay. Get that bill to legal services, or that bill. So the court wants a copy. They want a copy. I also would say to get one to Mr. Friedman, but what I'm going to let happen is you get that to legal services, and I'm going to order as part of the order, and if you would, Ms. Kim, prepare an order that they are to reimburse her for her out-of-pocket expenses. Okay. All right. Was there anything else? Yes, Mr. McGuire.
I just want to know if I can get access to that list, the hotel room and stuff on 15.
Do you know about that, counsel?
Yes, Mr. McGuire indicated it expired to the 6th, so.
The 15th of this month, tomorrow? Okay, well, is his unit gonna be extended? I mean, what's gonna happen with him? You're in the hotel room now. All right.
This is extended, right?
All right, it will be extended. So. All right. Was there anything else from anyone?
Yes, Your Honor.
Yes, go ahead, Ms. Grove.
I apologize for intruding. I do have one question that my partner wanted me to really make sure that I ask. Because we were in the hotel for so long, obviously with 2 kids and the 2 of us, our groceries went exponentially high. Is there any kind of reimbursement for that or per diem?
Ma'am, yeah, I understand what you're saying, and I'm not going to at this point order anything regarding that, ma'am. What I will do is I'm going to, unless there's an objection from council, I am going to check, see if there are resources within the county that may be able to assist individuals in this way, but I don't know at this point. Okay, ma'am?
This is one of those moments where the judge gives a very honest answer, and it's not the answer the tenants probably wanted. Miss Grove raises a completely understandable question. If a family is stuck in hotels for an extended period, groceries go up, transportation gets harder, kids still have to get to school, routines get wrecked, is there any reimbursement for those extra costs? And Simpson's answer is basically, I hear the problem, but I'm not prepared to order that today. That's frustrating, but it's also legally revealing. Judges are often much more comfortable ordering reimbursement for a clearly documented expense tied directly to housing, like a hotel bill, than they are ordering compensation for broader ripple effects like food inflation, travel costs, or the everyday chaos that displacement causes. Not because those harms aren't real, but because they're harder to measure, harder to trace, and often fall into a gray area unless there's a very specific legal basis in front of the court. What Simpson does do, though, is important. He doesn't dismiss the concern. He puts it on the record, acknowledges that it was already discussed in chambers, and says he wants to see whether county resources exist to help families dealing with exactly this kind of displacement burden. That matters because it shows the court understands this isn't just a fix the apartment case anymore. It's a survival logistics case.
No problem. Thank you, Your Honor.
I do hear you, and I understand that. And that was something that was, while we were in back talking, was brought up regarding food costs, regarding also just trying to get kids back and forth from school and just additional travel costs, and where are the resources to help folks regarding that. So it was brought up. I'm just not prepared to rule in on that at this point.
Totally understand, Your Honor.
All right.
I have a
Yes, Ms. Llewellyn, you had something else to say?
Yes, it was multiple reasons why I moved out, but my main question is my lease was up yesterday. How we go about that?
I'm sorry, your lease was up?
Yesterday.
Yes, I know. Okay, I think you had mentioned that to us.
Yeah.
So what's your question to me?
Is possible I can break my lease because I don't have a lease anymore? How do I go about breaking it and the money that I put in escrow on my own?
All right, there would have to be, you put money in escrow where?
At your courthouse in November.
At the courthouse.
Before you did a court.
Okay, there'll have to be a specific, okay, that would have to be specifically addressed by me if you were seeking return of that. And we did discuss that in the parameters of that. Ma'am, when you moved in, did you pay a security deposit?
I did.
Okay, and how much was that security?
I want to say $1,000. I'm not for sure.
Okay, so what I'm going to ask you to do, you guys have you been working with Miss Fluent? All right. I'm going to ask you to contact legal services. We also talked about the parameters of how all of that was going to occur.
This part shifts the hearing into another crucial lane: how tenants who have already moved out disentangle themselves from the property relationship altogether. Miss Fluellen isn't asking for a new hotel or a repair timeline. She's asking the question that comes after someone has already had enough. What happens to the lease? What happens to the escrow money? And what happens to the security deposit if you're done with this place and want out for good? Judge Simpson's answer here is measured, but it tells you something important. He's not casually promising money back on the spot, and he's not issuing an instant lease termination ruling from the bench without the paperwork lined up. Instead, he's steering the issue through legal services and framing it as part of a broader process. If someone has moved out and is relinquishing rights to the unit, there are parameters for how that gets handled, and the court wants it done in an organized way rather than through improvisation. That matters because it shows the hearing isn't just about emergency relocation anymore. It's also about exit rights. Some tenants may want safe replacement housing and to stay connected to the property relationship. Others may be completely finished and want their money sorted out, their obligations ended, and their names clear of the whole situation.
Okay.
For people that have moved out and who would then be relinquishing any right to the unit, and how we work that out. So I would prefer that you talk with them, and then we can see where we can go from there. Okay.
Okay, because the reason why I really moved out is when it rained, it floods, and my heat wasn't working, and I'm asthmatic. It's black bowl.
I got you. I hear you on everything. Let's just see if we can try to do the separation. How we're going to do that? Okay.
Okay.
All right. You heard something else? No, I'm not. I was pointing at you.
Sorry. No, I'll just walk to the corner.
Okay. All right. Okay, folks, that's it. And then what I'm going to do is I'm going to adjourn these matters out. I'm keeping them on a tight leash so that as these other ones come up. And so I'm going to adjourn it to April 28th at 9 a.m. For those who want to testify to the court, I'm going to ask you to coordinate through legal services and counsel so that maybe they're staggered throughout the day so they're not here all the time. I basically set aside that time so that we can deal with all of this. That doesn't mean you can take it, but yes. All right, yes. I basically set that aside, but the way my life goes, you never know what's going to come up and what I will have to deal with. The gentleman from Ipsy, what was the day all of the buildings became red tagged?
This may look like a small factual cleanup question, but it's actually a critical moment in the hearing because Judge Simpson is pinning down the timeline of condemnation. And in a case like this, dates matter a lot. Once the court establishes when the buildings were red tagged and when all of them were fully red tagged, that timeline can affect everything from notice obligations to relocation urgency to how the court views any later claim that tenants abandoned units or failed to cooperate. Why is Simpson drilling down on it here? Because by this point, he's not just dealing with abstract complaints. He's building a record for ongoing supervision of these cases. If all buildings were red tagged by April 8th, then the court wants a clean anchor point for what happened after that. Who was still in units, who was told to leave, who was placed in hotels, what instructions tenants got, and whether management's conduct after condemnation was actually reasonable. This is also where the hearing starts to show its longer-term shape. Simpson isn't treating this as one afternoon of venting followed by "good luck, everybody." He's setting dates, preserving facts, and making sure the next round of proceedings has a clearer foundation than the first one did. That's why this question matters. It turns a messy housing disaster into a more structured judicial record.
That, if you know what I mean, that was a very badly...
April 8th was the last day of the red tag buildings. The first red tag building was on the 21st of February.
Okay, so as of April 8th, all the buildings were red tagged.
I have a printed copy, but I don't have it. Even just to make sure they have a date, maybe give them 7 days to respond so that all their things are put out.
Well, well, they shouldn't be throwing anything out of any of these units. I mean, it's almost the assumption has to be made that they've left their unit at least temporarily because of the condemnation. I think they've run, I'm not going to specifically address it, but I will say that there probably going to be some issues if they're declaring these units abandoned under these circumstances. So, yes, ma'am.
Sorry, my last name. I had a note on my door and I meant to bring it in and take a picture of it. It still says pay Arbor 1 instead of pay to the court. I'm going to take a picture and send it to legal services so they can put it into the court. But yeah, it's still saying pay them instead of the court.
Pay the court or pay the city of Ypsilanti. It's all right. No, I got you. It's really as simple as that. All right.
This final stretch is deceptively important because it shows the court still actively policing the money flow even at the end of the hearing. A tenant reports receiving a notice telling her to pay Arbor 1 directly instead of paying the court, and Simpson's reaction is immediate. He doesn't brush it off as confusion or miscommunication. He treats it as something that needs to be checked. And he should. In a case where habitability, relocation, escrow, and court supervision are all colliding, payment instructions are not a minor detail. If rent is supposed to be paid into court escrow or to the city under certain circumstances, then a landlord-side instruction telling tenants to pay somewhere else can create a whole new layer of problems: confusion, possible non-compliance, disputes over whether someone is in default, and fights over whether money was paid to the right place. That's exactly the kind of mess a judge wants to shut down before it spreads. What makes this moment so telling is that it reinforces the overall theme of the hearing. Nothing about this situation is operating cleanly unless the court forces clarity into it. The buildings are condemned, relocation has been chaotic, reimbursement issues are surfacing, lease exits are unresolved, and now even the rent payment instructions appear muddy. Simpson's role by the end of this hearing isn't just to referee a dispute. It's to impose order on a property crisis that keeps generating new fires every few minutes.
I don't know who's sending those. I will get to the bottom of it. I'm going to tell you, for any rental payments, if you have a case pending before the court, you are to pay that to the court escrow or the city of Ypsilanti. If you do not have a case pending, you pay it to the city of Ypsilanti. Is that it, folks? Yes, you can go. All right, that's it.
What a closing to a hearing that started as a landlord-tenant matter and ended up feeling like a full emergency management audit. By the time Judge Simpson wraps this up, the record is packed with testimony about condemned buildings, repeated hotel moves, unclear deadlines, units with no heat, ceilings collapsing, water intrusion, tenants paying hotel costs themselves, families trying to keep children in school, and residents asking the most basic question of all: where are we supposed to live safely while this gets sorted out? And Simpson's ruling reflects that shift. He doesn't treat relocation as a box to check. He orders that the affected tenants be moved into places that actually comply with housing and safety codes. He requires clearer hotel stay notice so people aren't left guessing whether they'll be thrown out in 3 days. He opens the door to reimbursement for out-of-pocket hotel expenses. He directs tenants toward legal services for lease separation, escrow issues, and deposit-related questions. And he makes clear that rent payments, where applicable, must go through the proper court or city channels, not through a confusing side route. The big takeaway from this hearing is simple. Judge Simpson saw a housing emergency, not just a paperwork dispute. And once he realized families were being displaced from red-tagged buildings into uncertainty, he started using the court's authority to force structure, safety, and accountability into a situation that sounded dangerously short on all three. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.